Yes. Petitioner, my lord. Council for you. Respondent number 1 to 5. 1 to 5. As short for an application for 5 application. 3, 4.
These for 3, 4, 5, and 7.
3, 4, 5. Is the very long. Right.
Lord, I beg to appear on behalf of the ED, but I am not. I can't hear the court, my lord. I'm the special prosecutor in this, my lord. My lord is not audible, my lord. We need two weeks time, my lord, to file a response. Now my lord is audible. Now my lord is audible.
Now you're.
Yes, my lord.
So you are appearing on behalf of whom, Mr. Hussain?
I am appearing on behalf of the Enforcement Directorate. I need 2 weeks to put in my counter. They have not even filed the prosecution complaint. And my lord is aware in PMLA matters, the threshold for bail is section 45, mandatory twin conditions. I will have to place our response on record. Today is the first effective day, my lord. I'll accept notice and file my counter affidavit or a reply, my lord.
So you are
Or objection.
affidavit.
Yes, my lord. Affidavit in affidavit in objection, my lord.
No, you are. It is subsequent for 15 days of 16 days. So we want that. I want that you should file it by 7 days. Is it possible for you?
My lord, there are two applications. If my lord if my lord gives me 2 weeks, I'll point out why, my lord.
And then
Generally,
Sakit will not be there.
An objection filed below is already on record.
10 days. 10 days.
It will come on Thursday. Fourth of it. Thursday of.
Please check your.
Realistically, my lord, 1 week is too short because their petition is very lengthy. Very lengthy. I am not as brilliant as Kabir. Take some more time, but he is extremely busy.
Tamil is a very good place. Please come on Friday and enjoy it Sunday. Okay, I'm fixing it on Friday. Next Friday. Okay. We'll have a council about the town.
Hello, may I request?
Yes.
May I only make one request, my lord? Friday is the 6th. Would my lord be kind enough to place it on 9th?
I put to the,
The last, I mean, add in of the.
no, my lord, back end was not possible.
So I'll give you, Friday, right, so please try to.
Let it be on
We
the
will
Thursday.
try. We'll try, my lord. Friday. We'll try. Friday we'll try. Very good.
We responded, official responded as sought for an accommodation for filing. Counter affidavit.
Objection to the election to bail.
Objection to the written objection to bail application filed by the citizen. Stop. The United Council for the citizen basis of. Stop. Let the, that can be fixed on,
Six.
sixth, April 2026. Objection usually we find will be this time. We can advance probably the other side.
One, whether the prosecution complains, since the bail application to qualify this file, even if it's a separate file, that you will take. That's the charge sheet prosecution complaint case.
Synopsis or something like that.
No, not full set of charge sheet, because it's a complaint case, there is no charge sheet, complaint has to be filed. This is that not complaint.
A copy of the complaint,
It's a complaint case, my lord.
yes, a copy of the complaint as is filed on behalf of the petitioner is the case.
Copy, maybe given.
Yes, copy served to the.
It's your complaint. ED can't complain, ED's own complaint, they don't have a copy, they want the copy. They are wanting their own.
No.
Okay, Mr.
But I'm generous enough to give me.
Oblige, my lord.
Friday, next.
On-
Friday.
Lord, our presence may be noted, my lord. I'm assisted by my learned friend.
Yes,
I will give the name.
the United Council, senior council, appearing from the United Council, probably senior council, will be have sought for an application. Senior council, appearing for an application.
Deeply.
In this case, I have also filed one case application, which is being listed tomorrow. So I have already served the advance copy. The same day. Yes.
All these matters can be tagged together.
So 3 and 4, no?
Yeah, 3 and 4 tomorrow my matter will come. That may also be fixed on Friday.
Active order.
It is 4. Same order.
Yes.
Actually, five, there are four original people.
4 is the same.
Same order.
Okay.
And I, my lord, I am appealing for the petitioner service.
Yes, please. About
Service has not been affected, my lord. I have tried to serve this upon the council. He has requested me to serve upon the party. Next week,
that council for the general has submitted that service from office. They sought for an accommodation. This will attract the money. On that day, the United Council can find out. And then give a service. And I think the party the question. First, that's, then follows the Sixth level. Now, what is that? Can that one? The applicant, the taking that one.
can must stay, my lord. Stay.
I can see, you are the street for the.
I am appealing. So far as item 6 is concerned, my lord, I am having some embarrassment because I am here for fear. But the Calcutta has still not reached my learned applicant. My lord, I am appearing on a complainant in this matter. Private counsel party.
And you,
I am for the.
I am for the state.
what is the, is about?
I am paying for washing of.
Will you
But
available?
156.3 was done, preliminary inquiry called for, preliminary inquiry report comes in a sort of 50-50 situation. In that situation, CGM says, when 50 is there, FIR launched. Now you investigate, once investigation is done.
No. Inquiry, how is the forthcoming?
Now, we will see that report, let that be seen. Let that be seen. So my submissions are out of a Calcutta, it is a little dangerous for me to address.
Does it counsel for the confident and some, the respondent, private respondent number?
Two.
Two. That's not for an accommodation for private development number. Stop. This is a joint.
Monday. By Monday, we will get. But may I make a very humble suggestion? My learned friend has said that the preliminary inquiry is in his favor. He has not annexed it.
No, I am not entitled to get that preliminary inquiry.
Exactly. So let me speak myself. He has not annexed it. So that preliminary inquiry report will be with the TCR. Will it be your lordship's pleasure to call for that in the meantime? Because on Monday, if the lordship is taking it,
Monday it can be done.
next room, my lord.
What is here?
This is Andaman's next room.
On the request of the land council of the party. Very clear. Can go before the report.
That will make it easier for everyone because the record will be there. Oh, those fellows are very good.
No.
Instead, I will 32%. I think it's supposed to be.
I'm appealing for the, I'm appealing for the. I think it's seven. I'm for the. Kavita, really? Well, it was served on 16th of. February of 7.
Already ended.
So, good, I have served it, my lord, on 16th of February. It's not 5 minutes, but it is there. 16 minutes. He is appealing.
I can give you copies.
The third is both the respondent on 16/1/2026.
We have to file an application to start.
He is appealing.
I will take this lesson.
I don't know.
No.
You are sitting there. Yeah.
Just,
Because it is said on 16/1.
Yes. yes.
You have to file application to start. Land council for the consideration.
In course of the day, I'll file it.
This is supposed, that will be a activity of service, course of the day, no, this is not Monday.
Will that be a 3 day?
Hey, W 32 of 120.
Based upon the private respondent, the black report has not been.
Council for the petition has come up with an affidavit of service. Happy support. Private respondent. And it's not certain that's complete.
I think government had it.
That's what private respondent wants some information. It's a matter of. We take care of it. You see.
I my W 36 of 120.
I'm for the petitioner. I approached the Tahsildar Miller for eviction of the private respondents.
I'm appealing on behalf of respondent 1, 2, and 3.
All response here.
No, Miller.
Private respondents.
I'm submitting, sir. The earlier the private respondent approached this number. I received copy in portal. They did not serve me. The kindly come to page, that order is at page 11.
That is another,
It is connected with this case only.
that is.
Miller, I may be permitted to serve upon the 11th council who appeared in the matter.
On the request of the council, is participation of the petition to be levied advocates of.
Sri K. Vijay Kumar,
Advocates of
private respondents,
private respondents. Number
4 to 11.
This is around question.
I will try to write, sir. Tomorrow it may reach.
Oh, no, what is strategy?
Monday, my lord.
Monday, then Monday.
All right.
Explain W 37 of 120.
This is not applied upon private respondent.
Which like, you guys counted. It's short for an. One taking service of this. Private responses. It's a matter of future.
But right,
Findings, no.
next week, right?
Next findings.
It appears for the municipal council. I have not received a copy.
Council, I get it. Commission or something.
Council.
As submitted that. This is not yourself. It's it. Any copy? No. Copy yourself. See what. If you use a council of each other. To serve a copy of your petition. Coming council. Council of the. Is for a number?
Shows to not much more number one. Blair.
There are 54 and 24.
And for the response. My senior is ready, madam.
And if it is my fault, something, right? Here, due to some personal difficulty, as positive. Sorry. Presently, who private added responding numbers. 8, 4 and 5.
Private responses. And for the petition.
United Council for the private respondents has sought for an accommodation as this senior council is not able to keep it stop. Please matter on when.
Yes.
Yes.
If it's a seated because it's a written matter.
Very well. Could they please say? So there is this ready matter. Yes.
Whether the private respondent has filed their opposition or not. Private respondents have not filed their opposition.
They are given time to file up.
Yes, sir. Last condition.
Private respondents are. It is better to file activity in nominations. Ready? Okay. We are fixing later.
Tuesday.
Okay, you will let it file activity. That's all.
Here. 55.
Pilot app for the. Not your. Matter was taken off my lord a day before yesterday. It was the empty matter today for the.
Yes, I am ready.
Yes, sir. We don't have led by Mr. Chatterjee, he will join. You know, in the meantime, your lordship, my lord, the first order passed by your lordship by Justice Gaurav Khan. Your lordship will get a brief idea of the matter. What is the case of the petition? It's a very short matter, my lord, short issue word. Challenging an order of the
Actually, file
administration.
any activity.
Yes, yes, it is all completed. Everything fine. Yes, yes, everything fine. Everything.
That is the order. I will get order.
Yes, sir. The first order passed by Justice Gaurav Khan matter.
It is.
Dated 1st September 2020. Yes, 1st September 2020. Matter has all are recorded. So your lordship will get a yes.
So, but reality of the order dated 51/2025.
Yes, yes, yes. Now, my lord, I will take your lordship, my lord, directly to the impugn order. But before that, my lord, can I just indicate that precisely the ground of rejection in the impugn order. The
Ground of rejection dated
impugn order that I am challenging, that is dated 15th January 2025. My lord, on two grounds, the administration has rejected my claim.
This one 2025.
Yes, so this is under challenge. That is that page 493, volume 3 of the petition.
Page number
493, volume 3. I'm checking your lordship. May I just kindly allow me 5 minutes. My lord, your lordship has seen the order of Justice Clark. My lord, your lordship has so the first ex gratia amount, my lord, was granted 7 lakhs and odd, and immediately thereafter the administration my lord passed an order for refund of that amount. According to them, that amount was granted to me by mistake. Inadvertently, they granted that amount. We challenged that order of refund by the administration before this honorable court. That was in 2010. That writ petition, my lord, was disposed of by his lordship, my lord, Justice Topin Chen, as his lordship then was, my lord, wherein the ground, my lord, agitated by the administration, one of the ground was, in fact, it was a primary ground of according to that, why I am not entitled to get any compensation, that I am not eligible as a farmer. Because the scheme is available only for the poor and marginal farmer. I, being a corporate entity, though I am involved in a business of farming or plantation, I am not entitled, being a corporate entity. This issue was considered thoroughly by the Honorable Court. I will take your lordship to that to the judgment, and it was ultimately held that the administration cannot bifurcate, and the scheme doesn't show that it is only available to the poor and marginal farmer, and in any event, it's a constitutional violation. You cannot distinguish, discriminate. Because I have also suffered, everybody has suffered due to tsunami, and tsunami was happened in 2004. So it was this.
because tsunami did not discriminate.
So this was Mirror, Honorable High Court Mirror rejected the claim of the administration on this ground, and the order of refund was rejected, and they were directed to reassess. They have challenged that order before the division bench, where they have failed. The Honorable Division Bench also affirmed the order of the learned tribunal. Thereafter, administration did not do anything. In 2017, my lord, 2015, my lord, I again approached this Honorable Court, my lord, by filing a petition. His Lordship Justice I.P. Mukherjee, by a judgment dated 9th June 2017, my lord, directed them to reassess the compensation and comply with the orders previously passed by this Honorable Court. That was of 2012.
So many order.
Yes, yes, my lord.
No, I
Yes.
have a question. Asking them to
Yes, yes, yes.
But why no complaint? Complaint the question was.
My lord, I'm coming to that because it's merely a mathematical calculation, and they are sitting right over the issue on. Now, in the impugned order, your lordship will find one of the ground of rejection was again that the scheme is available not to the poor and marginal farmers, not I as a corporate entity. Your lordship, I will see. So the impugned order under challenge, my lord, at the face of it, my lord, is contrary to the judgment passed by the, and that issue is not open to the administration today. And so far the second issue is concerned that my grant was subsisted 2014, though civil suit is pending where the injunction is granted in my favor and until today I am in possession of the property. Where I am claiming that I am entitled to hold the property till 2044 as per the statutory regulations. So there is a protection. And in any event, the cause of action arose in 2004, where admittedly in the opposition, I was holding a valid possession in the property. There is a circular of 2012 that they have disclosed in 2022 proceeding. 2022 proceeding only, first time we came to learn about, there is a scheme granted by the central government where certain lands that belongs to me were submerged by the compensation as regards to that. So the second rejection, the second round of rejection by compensation in the impugned order, your lordship will find that my grant was expired in 2014, so I am not entitled. Though the cause of action arose in 2004. Mr. Chatterjee, senior advocate, is there. Please reading.
Mr. Hussain has placed the facts before your lordship. Milord, your lordship will find from the impugned order, Milord, it's a scheme under Milord framed by the central government. The scheme says anybody who's affected, Milord, by the tsunami is entitled to the money, Milord, which has been granted by them. Milord, my lord?
Scheme dated.
Mr. Hussain, can you please?
My lord, there are several schemes, my lord.
The first one, it starts off.
My lord, it is of 2012. My lord, I'm giving the date. Exact date.
But it was the first one in 2012. Then there were several orders from this Honorable High Court which says that I was entitled to it. So it's no longer res integra, my lord, before the authorities to say that I'm not entitled to that scheme. What they say, my lord.
And then again, there was a order that UBS sent or something like that.
My lord, I'll show your lordship that. Yes. Now it's no longer res integra, my lord, on the authorities to say that I'm not entitled to because my lease has not, my lord, been extended. That is a separate, my lord, litigation which is on in the civil court and where I am enjoying an order of injunction.
Yes.
So all this, my lord, needs to be taken into account, my lord, when they will have to reject it. They can't simply say that I will not give you. They are authorities, my lord. They are state authorities. They have to act in terms of the law. My lord, it's not like a private individual who can say that I like your face, it's fine, I'll give you. But if I don't like your face, I won't give you. But if I'm entitled to, my lord, under the scheme, and the high courts have held that, they can't, my lord, go back now and say, my lord, that I'm not entitled to the money. This is the, my lord, the short point which is involved, my lord, in this writ petition. There is nothing beyond it at all. So, my lord, if your lordship sees, my lord.
On 15/1/2025.
My lord, if your lord, I'm sorry, my lord, it didn't.
Why you have challenged order 15/1/2025? What is the reason?
Petition. Volume. My lord, kindly have a look at my press. I'll show your lordship why. Kindly turn to 36.
Volume 1.
Volume 1. 15 January 2025. 15 January 2025.
15 January last year.
And that order, my lord, your lordship will find at 493.
Volume.
Yes, ma'am. And there, my lord, the reason why, my lord, I am challenging, kindly sees, my lord, 496.
496.
Volume three.
Volume 3.
Volume 3.
Yes.
Volume 3. Because this is the impugned order. Starts off from 493.
Yes.
Allow me to place it for your lordship's kind consideration. Whereas by an order dated 8th November 2024 has been passed by the division bench of the Honorable High Court at Calcutta at Port Blair, wherein the operative part of the order is that for the above reasons, the impugned judgment is unsustainable and is set aside. The appellate administration is directed to consider and dispose of the application dated 7th of March 2018, filed by the respondent number 1 in accordance with law. The above exercise is to be completed within a period of 12 weeks from the date of communication of this order and after granting an opportunity of hearing to any of the affected parties if necessary. It is made clear that the appellate administration will consider the application filed by the respondent number 1 without being influenced by any of the observation. In conclusion, it is important to highlight that the history of land insofar as the Andaman and Nicobar Island is concerned is in many ways sui generis. Most of the demography of the islands derived from pre and post independence settlement policies. Land was a basis of both sustenance and identity of settlers coming from the mainland. There have been chronic land issues pertaining to the land at Andamans. Development options are severely constrained due to acute shortage of land. To add to this is the genuineness and veracity of the land records, an avowed aim of all concerned being to keep the islands free from contamination. Lord, your lordship need not trouble your lordship says this is basically the history which has been given, does not in any manner affect the litigation in any way. Turns to Lord 494. The grant, acceptance of the grant, this is important that there was a grant in my favor and they admit that. And whereas the grant in respect of an area of 177 acres, 7 canals, 6 marlas of land bearing plot number such and such, by the Chief Commissioner under Section 4.1 of the Andaman such and such in favor of Haji Muhammad Akhtar and Kumari Majida Bibi for a period of 30 years commencing from such and such. And whereas the grant in respect of an area of such and such comes down below for a period of 30 years from 1955 for a purpose of long-lived crop. Then below 887 acres, 4 canals comes down for live crop again to Milord Haji Kumari Bibi. And whereas after finalization of the records which have been completed during the year 1961, whereby new survey numbers have been assigned against the old survey number in respect of Mithakuri, Bamboo Flat and North Bay Village respectively. Therefore, during the renewal of grant, new survey numbers were mentioned in place of old survey number. And whereas the renewal of grant for further period of 30 years in respect of land bearing such and such, and the extent of such and such hectare situated at Mithakuri village under Ferryganj Tehsil was allowed by the Lieutenant Governor Andaman and Nicobar Islands under 146, such and such commencing from such and such. It categorically provided that no further renewal of grant would be made by the administration. Kindly marks this. This is important because this is the subject matter of the suit. Whether the grant, the second grant bill I'm entitled to under the law or not is the subject matter of the suit, which I will show your lordship later if required. And whereas the renewal of grant for further period of 30 years in respect of such and such to the extent of total such and such was granted by the learned Lieutenant Governor such and such under 146 revenue such and such, it categorically provided that no further renewal of grant would be made by the administration. The renewal of grant for further period of 30 years in respect of such and such categorically provided that no further renewal. Your lordship again skips over that, comes down a little bit. Yes, kindly looks to mirror the fifth paragraph, and whereas in response to the Andaman and Nicobar administration letter, such and such regarding payment of compensation in lieu of land submerged due to tsunami during the year such and such, the Government of India, by letter such and such, conveyed the approval of the competent authority for payment of compensation of such and such per hectare. This is the amount, my lord, which is fixed by the government of India itself. In lieu of the submerged land at etc. directed that before making compensation, the administration shall ensure that the beneficiaries who get compensation of submerged land surrendered the land for which compensation is paid, and the persons who have claimed compensation have not encroached any government forest land in any of the islands under the Andaman and Nicobar Islands. And whereas ample opportunity was provided to the party concerned and the party was heard on length during the time of hearing, and also the relevant documents upon the respondent authority is relied upon, inspected by the party. And whereas in a similar case wherein the grant was initially permitted at Shore Point Village and subsequently on the rejection of the renewal by the administration, the matter was challenged before the Honorable Supreme Court, whereby the Honorable Supreme Court of India delivered judgment dated such and such, the operative part of the order is produced as under. To the extent of the unexpired period of grant as on the date the 1966 regulations came into force, the grantee would continue to enjoy his right and be subject to liability under the 1966 regulations. Upon expiry of the period of grant, however, the grantee will be liable to surrender possession just as the grantee is liable to do under Regulation 146 in regard to a grant made under 1966 regulations. The essence of the regulation insofar as right of the grantee to continue in possession is concerned is the same under 1926 regulations and the subsequent regulations of the year 1966. In either of the cases, the grantee cannot stay in possession for more than 60 years. The argument that an old grantee can stay in possession, my lord, again, this is not what your lordship is really bothered at the present moment. And whereas on bare perusal of the guidelines as issued by the Government of India, National Disaster Management, such and such, by order at such and such, it is clearly mentioned that ex gratia relief in the agricultural sector is only admissible for eligible for small and marginal farmers. The Andaman and Plantation and Development Corporation Limited is a body incorporated under, and below we shall show that this is no longer res integra. The High Court has held that, beloved, I am entitled to whether the farmer is big or small. It is nobody's case, beloved, that it's only a small farmer will get and a larger farmer will not get. Not for a moment, beloved, am I saying that I am a large farmer by any stretch of imagination. But the question is that this is one of the perversities in the judgment itself, in the order itself, not the judgment, in the order. And whereas it is not out of context to elucidate that an order has already been issued by the Assistant Commissioner such and such, wherein it was observed that as per the policy decision of the Government of India, the ex gratia which was specially released to provide the eligible small and marginal farmers, and the same was informed to the managing director such and such, an amount of 7,679 lakhs had inadvertently been sanctioned, whereby directed to deposit the amount in favor of account officer such and such, but not deposited on the basis of the order passed by the Honorable High Court in the matter of FMA number 005 of such and such. The Lieutenant Governor, in spite of that, pray for the payment of additional compensation of 11 crores and odd with interest according to the internal assessment of the company itself for the loss alleged to be incurred, which is not according to the norms and is not acceptable. And whereas the subject land is a grant land, which is of the nature of lease, the question of surrendering the same and availing compensation under the scheme does not arise, and therefore the claim of the Andaman plantation is rendered completely infructuous. Well, this is absolutely absurd. Absurd to the extent, Milord, that it's got nothing to do, Milord, with the factual situation. Now, therefore, after the careful circumspection of the case, I am of the considered opinion that in the light of judgment delivered by the Honorable Supreme Court, it is ostensibly clear that the grantee cannot stay in possession for more than 60 years. Marks this, my lord. Strictly speaking, the grant of land in favor of Andaman is not for endless duration, as the grantee after the expiry of grant period is only an encroacher. So, my lord, they are saying that I will not give you the money because I am an encroacher. My lord, this dispute is the subject matter of the civil litigation, which has said that I am to remain in possession, and there is an injunction that you cannot touch me. You cannot touch me. That's the injunction which has been granted by the civil court. They filed, my lord, an application under Order 7, Rule 11. That Order 7, Rule 11 application, my lord, was initially, my lord, allowed by the trial court. That was carried in appeal, my lord, before the district court, where, my lord, that order was being set aside. And, my lord, it has been directed that, my lord, that the suit has to proceed with in the way, the manner it is. They challenged it before the High Court. They have lost it in every forum possible. My lord, they filed a revision. That was first appeal. That was held to be not maintainable. They filed a revision. Again, it was held not maintainable. They have thereafter, my lord, accepted the order passed, my lord, by the district court. So now, my lord, the suit proceeds, and in that suit, my possession is accepted, and there is an injunction which says that they cannot touch my possession. So the question of treating me, my lord, as an encroacher is absolutely farcical and perverse and arbitrary. Because if
I want to know, so we completed the 16 years person in 2004, right?
Milord, the question is whether under the law I am entitled to, Milord, one extra in 30 years. The question in the civil court is whether, Milord, I'm entitled to that extension of 30 years or not. Whether I have one extension or whether I can have more than one extensions. The question here is, Milord, we are saying the second extension was a fresh lease. That was not an extension. So under the regulation itself, my lord, I am entitled to a further possession of 30 years. If the 60 years has got nothing to do with me, it's got nothing to do with me. This is the perversity, my lord, that they want to, my lord, get into.
And I know that 30 years, my lord, was till 2014, whereas the further matter was in 2004.
Yes, absolutely correct.
Is that already a complex 60 years of
Milord, the question of 60 years here doesn't even apply because, Milord, the question in the suit is whether, Milord, the second grant was a fresh grant or whether it was, Milord, an extension. In that, the High Court has said, Milord, that whatever it is, I am in possession and my possession cannot be touched. If that is so, Milord, I am not an encroacher. I am not an encroacher.
There are conventional marriages for an incident which took place in India 2004.
My lord?
It was within the period of grant.
No, it is. Tsunami happened within the period of grant. When the tsunami happened,
Keep my question.
Yes,
absolutely. My lord, it is nobody's dispute when.
It was
My
valid.
lord, bow down. I completely bow down. I'm so grateful to your lordship.
That's why I'm
So grateful. So grateful. My lord. So when the tsunami happened, the grant was still there. Whatever the dispute, there was no dispute that at that point of time, my lord, the grant was there. When the tsunami happened, it's not about what happens later. When the tsunami happened, my lord, even if you say, my lord, I'm an encroacher today,
now we are complicated.
my lord, there are a few things that we need to show your lordship.
So, not granted to other.
কি করবো?
No,
Mr. Hus,
Justice Standard ordered the just place for.
huh?
Justice said, farmer issue.
Yes.
Only
Mr.
paragraph.
Hussain, go ahead and place it. Because there's a problem with the hearing of the.
Your Lordship kindly come to 131 from volume 1.
131 you can.
Count that in.
On 31. Yes.
Yes. Yes, this is the first writ petition, my lord. We filed, my lord, challenging it.
There are two petitions. One is
My lord, sees the right hand bottom top.
The volume 1 of writ petition, your Annexure P5. Annexure P5. Volume one. Yes, volume one.
Lord, what I would suggest, Mr. Hussain, is that kindly shows my lord first the scheme, which you will find at 360. It would be beneficial for my lord to first see the scheme and how we fall under that, then the orders will come into play.
Yes, sorry, sir.
Yes, so.
360.
Lord, volume three.
The volume kata bol? 3. Volume 3. I'm sorry, volume 2.
Volume 2. Volume 2.
360. madam.
60.
360.
Event of compensation, event of plans.
My lord, during tsunami of 2004, I am directed to refer to Andaman and Nicobar administration dated such and such to be subject and in convey the approval of the competent authority for payment of compensation amounting to rupees such and such of 100 crores to such afforded persons whose land submerged in tsunami of 2004 and who gave specific option to get compensation in cash in lieu of their submerged land. The payment will be made at such and such hectare in respect of such and such. Owners have been for compensation in cash in lieu of the submerged land. The payment of compensation will be made by UT administration only after ensuring availability of funds through supplementary grants, proposal for which is such and such. Before making compensation, administration will further ensure that the beneficiaries who get compensation land of by which compensation is paid and the persons who have claimed compensation have not encroached and any government forest land in any of the islands under the administration Andaman and Nicobar Islands. The expenditure will be debited by such and such.
So far as the first condition is concerned, that you have
My-
to surrender the land also.
My lord,
You have to surrender the land also.
but it's submerged. It's submerged.
Whatever it is.
They have not said, my lord, that I will not do that. It is not their case, my lord, in the order. They have not said that I am not surrendering land or I am not doing anything of that sort. It's not that. My lord, they kindly looks to the impugned order once. They are not saying that at all.
It made the software.
Oh, you already.
Yes, yes.
Okay.
Because below this circular minor was disclosed by the administration in 2022 proceeding. Prior to that, they kept this circular with them. It was not known to us.
Okay.
Pursuant to the direction below they disclosed.
So we have come to know about the scheme of 2008.
Yes, below the kindly take volume 1 below. Page 1. 131.
That's the initiation.
Yes.
131 petition.
Volume 1 below.
131 annexure.
5. Yes. Not judgment was kind of passed by the Lordship Justice. Yes. Justice said.
Apprehension.
And thereafter the scheme was
This scheme was there. It was known to them in 2022 below third round of litigation. My lord, we filed another writ petition below after that.
1 second, Mr. Hussain. My lord, kindly looks to page 140, goes directly to that. 140.
yes, 140.
This is the reasoning. My lord, kindly got that, Lord?
Yes.
Mr. Hussain, you can place it. 140.
Yes. Lord, upon consideration the facts and circumstances, it is evident that none of the documents which have been referred by the respondents can establish that at the stage of creating
At the stage of creating a new post, tsunami, Andaman and Nicobar Islands, the administration took a policy decision in accordance with law that a distinction would be allowed between the rich and the poor. Kindly, Milord, marks this. Why I say, Milord, it was no longer res integra for them. In accordance with law, that a distinction would be allowed between the rich and the poor, and or between the big farmers and poor farmers. And even if such a decision has been taken, it would have been hit by the Article 14 of the Constitution of India. Marks this, one of the reasons for their refusal. In this case, the fact remains that the petitioner is also a farmer. Though registered as a company under the Companies Act, its activities are farming, and therefore it cannot be said that it is either a big farmer or a rich farmer or a more privileged farmer. The fact remains that it is a farmer dealing in farming activities and providing employment to at least 120 families who are receiving direct and regular employment from the petitioner company. In other words, the petitioner company is also a provider of employment to those who themselves occupy their time in farming activities and are not so well off. Very importantly, Milord, dealt with by Justice said in our matter, and it is no longer res integra. This is why I'm showing this, Milord, that this is not in dispute and this has already been settled by the High Court. They could not have, Milord, encroached upon the High Court's decision and given, Milord, a decision which renders this decision, Milord, fruitless. Then, nothing has been brought on record, save and except bold statements made in the affidavit in opposition that the scheme was meant only for small and marginal farmers. In fact, Annexure R1 is an office order such and such issued by the Deputy Commissioner, setting up a committee of officials for different locations to assess the damages caused in the Ferroganj Tehsil by tsunami or earthquake on 26th of December 2004. It does not say anywhere that the exercise would be confined within small and marginal farmers. Annexure R2 appears to be a list of farmers, but it does not throw any light nor lends any support to the respondents' qua their arguments that the scheme was for small and marginal farmers only and not for companies. Annexure R3 is also a document which does not lend support to the submission as referred to above. Similarly, Annexure R3 at page 41 also cannot be allowed to be used by the respondents to say that the scheme was meant for small and marginal farmers. It is under these circumstances that this court is not in a position to appreciate the stand taken by the respondents in issuing the impugned order dated such and such in the absence of any supportive documents to show that even in devastation, the government has a right to distinguish between the privileged and the underprivileged. This court is compelled to say that the impugned order is totally irrational, illegal, arbitrary, and is hit by Article 14 of the Constitution of India. Circumstances is quashed and set aside, restrained by the issue of prohibition, prohibiting them from taking any steps recovery for the interim compensation paid to the petitioner to a tune of 7.679 lakhs. So, Milord, that part of the Milord, the order goes.
Now, why
Two part.
Why you have? Why?
Ball. I'm shunting.
What had happened, Milord, after his judgment, they preferred an appeal. They lost. Thereafter, we waited for 2 years.
Let's show, my lord, the order of appeal 143.
I mean, I can just precisely submit. Now, Milord, thereafter, what happened? Milord, I'm coming to that. My lord, why? Because there was a direction there. Because there was a direction upon the administration to take a decision pursuant to the representation made by us in 2018. And that representation we made by the pursuant to the direction passed by this Honorable Court, Milord, by an order dated, by a judgment dated 9th June 2017, where we directed to make a fresh representation before. So we made that representation. My lord, a committee was formed by the administration. They took inspection of my property. Those are, my lord, we have placed those documents in the writ petition. Committees have also recorded that there is a certain 54 hectares of land, my lord, has been submerged. They also record that there is a old cultivation and trees were also gone. So those are there. Thereafter, they didn't take any decisions. We waited for until 2020. Then at that moment, we filed another writ petition. Why? Because they did not take any decision. There was a direction in 2017 by this honorable court.
Now, by 2017, they are already directed to take decision.
Yes.
Yes.
And they started,
Your Lordship,
they started,
because we are
planning and everything.
because we are
And they, ultimately, they,
but the administration is required to calculate the compensation amount. The loss I suffered, so that was there was no the direction was then to assess the compensation. That they were required to do, that they have not.
Hello?
That they have not.
this order was from Honorable High Court.
Yes.
But they started, but they did not complete. Why this is not, why there is no, content that? It assists me. Then again you are coming up with the, again and again.
Lordship, no specific direction from any
Lord,
honorable
may I-
court
may I-
to give a compensation.
My lord, may I show the order of 2017, my lord? That will, my lord, clear the position, my lord.
According to him, there is no
No
direction.
specific direction, pay the compensation
My lord, yes.
Assess.
and pay the compensation.
Yes, because the
Mr.
calculation.
Hussain, wait. Mr. Hussain, wait. Let Mr. Kormukar submit. We'll
They are not
understand.
Payment because they have assets, but they, as they are not directed to pay, so they did not pay. So it will. Mr. Congress,
Lordship, no specific direction. Assessment different thing, entitlement
one-
So
different thing.
very well, kindly directs it now, my lord. Mr. Kormukar requires a direction, kindly directs them.
Lordship, yeah. First of all,
whether
we
they are
have
assessed or not.
Lordship, kindly appreciate. First of all, after several litigations, what happened? Recent speaking order was passed that's the month of January 2025. On the basis of the order passed by this honorable court. Accordance with law, I have passed the order. Accordance with law. Never directed me to assess and give a compensation. Lordship, assessment.
Then again, why you have taken this is that small and.
Yes, I will come to the on two
That has been
grounds.
settled.
Lordship, no, kindly come to the notification, Government of India. Kindly again come to the notification, Government of India.
Yes.
Lordship, that is, Lordship has correctly pointed out that page number 360 of which was already Lordship had gone through just now. 360 of volume 2, repetition volume 2. Yes, that notification.
Mr. Hussain, please get the report from the administration out. That will be required.
Yes.
ওটাকে বের করে রাখ। Immediately after this, we'll have to show you.
Yes, please.
360 Lordship.
360.
First, payment of compensation to Chief Secretary, first paragraph, second paragraph, kindly very important, Lordship. The payment will be made at the rate rupees 9,39,000 per hectare in respect of 1136.44 hectares of submerged land for which specific option from their owners have been received by the UT administration of payment of compensation in case in lieu of submerged land. Lordship, regarding possession, I am not disputing because he was given a license on lease purpose, we can say grant as per local regulation. Regarding possession, civil suit pending, Lordship, for extension of that period. That is different aspect, I am admitting that. Lordship, first of all, they are not the owner. First, I need to note it. Because this word have been used, from their owners have been received by the UT administration for payment of compensation in cash in lieu of the submerged land. First point, very important. In this island, Lordship, we all cannot say the owner of the land. We are just a recorded tenant under administration, Lordship, as that defined in local regulation, Lordship.
They are recorded too.
They are recorded, not only recorded tenant, Lordship, they are grantee. License was issued, admitted position, documents have been filed, they have been given the land for certain purpose, it was extended timely. In the year 2004,
So in the, nobody is owner.
nobody is the owner.
Exactly. So grateful.
The
So
land
nobody gets the compensation.
administration is the owners.
Then why this,
No, we are the recorded tenant as per local regulation.
so all are recorded tenants.
All are recorded tenant.
Whether
Some condition has been given. Lordship, some condition given. First thing, that's point. Second, here admitted position, it was given as grant. That is the very vital. Given as a grant. This petitioner and applicants is a company. Lordship is a company. He used more than 500 employees, directly, indirectly. The petitioner is a company registered under the Company Act. So, as part of this notification, second clause, Lordship, the Lordship has already pointed out. Third one, the payment of commissioner will be made by the UT administration only after ensuring availability of funds through supplementary gains proposal for which stated have been done. Four, before making compensation, UT administration will further ensure that the beneficiary who get compensation in lieu of the submerged land surrendered the land for which compensation is paid.
Under the definition of tenant for the purpose of
Whether
that act.
any documents that they
That
have
is why the owner term is
that we
used.
are surrendering. Can you show any document that I am entitled to get a compensation after a tsunami? We are ready to surrender our landed property, which was given as a grant.
so saying that they are willing to surrender.
Now saying Lordship, any document have been filed before the authority
It is there,
concerned.
my lord, I will show it. It is there.
It is my submission. Let him show Lordship first. So here Lordship, surrender not done. First, surrender not done. I already submitted regarding recorded tenant, owner, possession doesn't mean that invested the ownership or the recorded tenant. Because certain condition, the land, huge chunks of land was given as a grant by the Andaman Nicobar administration. Then kindly come to the improved order which was passed by the
Is there any petition that they have imposed any land?
regarding encroach, nothing.
So only you, only first, 4-1.
4-1, then another administrative order. I will show Lordship. Kindly come to the improved order. Just a minute. Annex Lordship with my petition opposition. Page number start from
493 in the writ petition.
Lordship can be seen. I will read out from my
493.
of the writ petition.
Yes.
The page 3 of the improved order, kindly will see Lordship. Page 3 of the improved order, there are 1, 2, 3, 4, 5. Lordship, may I read Lordship? And whereas in response to the Andaman and Nicobar administration letter number such and such, revised dated 25th April 2012, regarding payment of compensation in lieu of land submerged due to tsunami during the year 2004, the Director ANL, Government of India, Minister of Home Affairs, legally filed letter number such and such, dated 30th July 2012, conveyed the approval of the competent authority for payment of compensation at the rate of 9,39,000 per hectare in lieu of the submerged land. Directed that before making compensation, the administrator shall ensure that the beneficiary who paid compensation in lieu of submerged land surrender the land for which compensation is paid. The person who have claimed compensation have not exposed. I am not on part 2, Lordship. I am on part 1. It is some relevant portion of the impugned. Then next page, Lordship, page number 4. My rejection not only on the ground, only one ground, that's regarding ownership, recorded land, or regarding surrender. Third point is very vital. Page number 4 of the impugned judgment order. Lordship, page number 4. Second paragraph. May I read, Lordship? Whereas on behalf perusal of the guidelines as issued by the Government of India, Minister of Home Affairs, National Disaster Management Division, filed letter number 32, 2005, NDM, dated 24th February 2005 and it read with the Andaman Nicobar Administration Order number 631 dated 19th February 2005 and subsequent order number 773 dated 1st March 2005. It is clearly mentioned that the ex gratia relief in the agriculture sector is only admissible for eligible small and marginal farmers, Lordship. Lordship, the petitioner is a registered company, Lordship.
But that issue has been settled.
No, Lordship, I will come to that order. How this honorable High Court had adjudicated that issue. I will come to that judgment also.
So they will now adjudicate the High Court's order.
I have not
No,
adjudicated.
this is unbelievable.
Lordship, what was the direction? To dispose my revegetation, the revegetation of the petition according to law.
It is no longer res integra for them to decide.
By improved judgment, we have passed the order. Again, that,
Bojo Thal.
by that order, we have passed this improved judgment on 2 grounds. That grounds have been,
You have taken this ground also that they are not small farm.
they are not a small farmer.
So whether it can be done or whether the High Court has already made an observation.
Lordship, observation, direction, Lordship, may submit, never directed the respondent to make a compensation. Lordship, 2 things, assessment, entitlement. My specific defense is that the petitioner is not entitled because the land was given as a grant. First, there is a violation of the scheme.
Surrender means what I have. Text of this is surrender of possession. Possession which they are now.
It's on paper only. Then second part of the order, may I read, Lordship? It is not part of my affidavit in opposition, Lordship. I may be allowed, but it is not a part of my affidavit in opposition. I have that notification. Lordship, that is the. May I read thereafter if required? I will file a supplement. That, Lordship.
I do not have.
Lordship, I am giving the copy. I have a spare copy. I will send my copy to other side. If required, I pray for by way of supplementary, I will file.
19th February 2005. Because it was placed before the High Court.
Lordship, that was not. That I will check. I will also check. Lordship.
But it's unbelievable that the authority will go above the High Court.
Lordship.
It is unbelievable that a lawyer can make a submission to that effect.
They are trying, but here all.
Lordship, several litigation, changing of briefs of the newly I have been appointed, Lordship. I personally have no knowledge.
Again,
No, Lordship, just a bit. But we cannot also ignore the some notification order. That is, may I read, Lordship? In the items of expenditure as per the norms by the government of India. First item, what is Lordship? Includes relief households article for affected families, B, temporary relief for affected families, relief to small business enterprises run in residential premises, assistance to small and marginal farmers for 2.
This is X plus here.
Lordship, that is it. Ex gratia was used after tsunami, that is compensation amount. On the basis of this order, on the basis of the notification of Government of India, it is clarified the how much amount in respect of how much hectares.
This
Kindly see
19 February 2005, my lord, considered by Justice and my lord. It is recorded in the order. So, my lord, this was considered. Whatever my lord friend is submitting.
so my
At
respectful
page
submission
133, my lord, it has been recorded.
I will thank you. Has already considered.
Yes, 133. Then please take 133. That has been considered. The first March is a partial modification. It's a partial modification of 19 February 2005. Kindly your lordship comes to 133 of volume 1, second paragraph. This 19 February 2005 minor was placed by the administration and it was duly considered by the honorable. And anyway, this judgment minor attains finality. There is no challenge to this. It is binding on them. You cannot reopen this at this stage. Page 133 below, second paragraph.
Lordship, volume 3 is, Lordship, volume 3, earlier, volume 3. Page number 455, Lordship.
55.
455. Everything has been discussed, all observations have been made.
That order has already been diluted by the judgment passed by the Honorable Supreme Court. We challenge that order before the Honorable Supreme Court.
Supreme Court never said. Honorable Lordship, kindly go through that judgment. Every aspect has been discussed. Everything. Thereafter, then our matter was allowed, Lordship.
According to them, according to that judgment, they are not entitled to something.
No, recent done. Entire aspect have been discussed, Lordship. Then our appeal was allowed.
Again, whether this order considered the judgment of the.
Yes, Lordship, yes.
Whether this.
All things have been considered. Thereafter, it went to the Supreme Court directed to file a fresh petition and instantly.
This order was almost set aside. Can Mr. Hussain please show?
If the Honorable Supreme Court did not affirm this and asked the petitioner to file case,
Exactly.
then what?
My key.
Why you have to call to Ahmedabad?
Milord,
That's the strategy.
Ash-
Told you, and this. Before we.
I'll be there, Milord. I'll be there.
I think.
Yes, the Supreme Court judgment by Lord, your Lordship will find in the supplementary list, the supplementary affidavit. And it was recorded by Lord.
I cannot understand why Mr. Kormakar is referring to this at all, because it's no longer reciting at all.
But Justice Kapoor, my Lord, ultimately directed the administration to consider the representation. That was filing 28. That is why this decision was taken.
Compensation has been reassessed.
Oh, Lordship, we have rejected by Yepung judgment.
They are saying I'm not entitled to even 1 rupee.
Lordship, again I submitted assessment, direction for assessment and directing us to give a compensation to different aspects. They are not entitled at all on 3 grounds.
On reassessment, you find that they are not.
Not entitled because the grant was given. Neither they are the recorded tenant, nor they are the owner of the property. As per the local regulation. Civil suit is pending for extension of the renewal period. That dispute is still under adjudication.
Who is the owner of that property?
Government administration.
So the administration gets the money.
Why this clause will be there?
Lordship, as per local regulation, I have done so.
This means surrender of position, surrender of immediate possession. I think, my interpretation is concerned. If they are willing to surrender, you have said that you are ready to.
Yes.
Why is your document that you are ready to?
Lordship, first thing, first grand land, grand land given on certain condition. Deed was executed between the administration and the petitioners.
Yes, exactly. Was not there.
There some condition was there. Grant land can be surrendered, Lordship. That is the second part also. If it is an admitted position, then it was grant.
application, means that they will surrender their possession to the administration. No, nothing there.
Where is the application, Lordship?
They will file application.
No, at this stage, after several litigation, Lordship, compensation we already were given after 2004. But on the basis of entitlement, Lordship, if suppose one land is given on lease agreement, if I will come, I am the owner of the property and submerge the land, give a compensation as per that notification, where there is a bar and the notification that order to
Not for the apart that, but courts merging, there were some construction, there were some.
Yes, Lordship, they are the registered company, Lordship. It is admitted huge plantation, more than 500 farmers.
If the company suffered some loss, they are not entitled.
No, as per the notification, why entitled, Lordship? Some encroacher will come. I am in possession since last 40 years. Then file application after 2004, then give a compensation.
So there was no grant to pay. There was no grant from your side to pay. When this land is being allocated for you for such period.
Yeah, the petitioner.
Yes.
Lordship, there is a document admitting position. Grant was given.
And was.
আবার কি তাহলে
Grant was
আর
given.
কি he admits this Milord. After this what remains?
The question is not a physical position. Question is grant, lease, ownership, that has to be decided. Suppose somebody come from the outside. Lordship, that for that reason, Lordship, civil suit is pending, Lordship. They have filed a civil suit for extension of grant period.
How is that you want to Calcutta or something like that?
I'm showing, Yes, kindly, your Lordship, I not come to 424 months. Your Lordship has referred the 424 volume 3 below.
Yes.
Yes, kindly come to paragraph 70. Paragraph 70.
70.
Yes. May I place your Lordship below? Insofar as the prayer of
24.
seeking a direction on the appellants to take a decision on the application filed by the writ petitioner on 7th March 2018 is concerned, there can be no objection to the same. The right to a decision is not only a cardinal requirement of good governance but also a rule of law. The appellant administration is obliged to promptly take such decisions. Though notice for reassessment had been issued, so they issued notice reassessment. I will show the notices as well. Issued by the appellant administration and an inspection carried out. No final decision has yet been arrived at. There are multiple of reasons as to why such decisions are not timely taken, stating that they are for deliberate inaction, resulting in our dockets being unnecessary final. However, the prayer for appointment of a special officer or receiver or any other authority adjudicate upon the question of compensation is without any legal justification has not been pressed. Similarly, the apprehension of the respondent number 1 as to the basis of any decision of the appellant administration of any particular circular notification or judgment is premature and misplaced. For the above reason, the issuing judgment is unsustainable and says the appellant is directed to consider and dispose of. Paragraph 18. The appellant is directed, second line, paragraph 18. The appellant is directed to consider and dispose of the application dated 7th March 2018 filed by the respondent number 1 in accordance with law. The above exercise is to be completed within a period of 12 weeks. So pursuant to this, they were to consider the made on 7th March 2018. 7th March 2018 representation was made pursuant to the direction passed by this honorable court. That I'm showing the order. Kindly come to. Kindly come to. Straight away comes to the report filed by them.
Yes. When kindly take volume 287.
287.
Yes. Here, what had happened, 2020, if you're not wants, I will place the order.
287 volume.
Moved a writ petition, for because they have not, because of the inaction of the administration. There, Justice I.P. Mukherjee, directed past certain directions upon them. One of the direction was that they will not consider the issue as regards to the ownership because
Arey, Mr. Hussain, Mr. Hussain, kindly goes directly to 288. অত বেশি বললে দরকার নেই এত। Because
Yes.
this is their finding. This is their finding with respect to our possession and the amount of land that we are in.
288. Yes, kindly see. It is their report submitted on 9th April 2018.
Yes.
The Assistant Commissioner, Relief and Disaster Management, did office order dated so and so. For reassessment of the claim of petitioner, as contained in common judgment in WP number 52 and so. In pursuance of the said order, a notice was issued to the committee members informing the date and field inspection of the subject land located in various villages. A copy of the notice was covered. Next, the committee visited the 3 locations in village, Mitakhari, Bamboo Flat, and North Bay on 6th April 2018. After the field inspection, consultation of the relevant records and the relevant documents of the committee came to the following conclusion. Now, in the respective plots of land, they have mentioned area of submerge.
So according to you, all the plots are.
Yes, it is their report. They took a physical inspection. They prepared this report. Now, the bottom paragraph is important. The total area of
block and North Bay.
Yes.
Property, you are in possession. You are in possession.
Yes. More than that, a portion of plot was submerged that they have mentioned it. At the column of area submerged as on. Now, kindly come to the last paragraph. The committee members representing agricultural department conveyed that the exact number of fruit-bearing trees purportedly standing on the subject land prior to tsunami submergence cannot be ascertained as on date, as per the documents made available by the party, including photographs of standing crop trees. It can be presumed that there exists a scientifically spaced and managed coconut plantation on the subject land. The sketch map showing the extent of submergence is enclosed here. So it is their report, and the next page 289 is the order. Sorry, order of 2006 explains the amount. So, this report, they took out an inspection admittedly. Report, they have also submitted, but no decision, as regards to the compensation. So far,
Below, this report was not even taken into consideration during the last order.
And the second, submerge of land. So these are the 2 things. So far, the notification of submerge of land, 2012, initially, we were not aware of. This was disclosed, in the proceeding of 2022 petition, we came to learn, that was directed by this honorable court to disclose.
Mr. Hussain, it's not necessary at this moment. Milord, what I am trying to, canvass before your lordship is, they were directed to dispose of, my application for compensation. Their ground of rejection is small farmer, big farmer. They have a report there with respect to, how much of money or how much of land, how much of trees, whatever it is, I am in possession of. This report is not even taken into consideration. Is not even taken into consideration. Big farmer, small farmer, no longer a settlement.
To ask compensation, you have to comply the condition of.
No, certainly, they have not even said anything on that ground.
We have, the London Council for the party have concluded their sufficient.
Lordship, one submission, Lordship, everybody. Filing civil suit.
Okay.
For extension of grant period, now in the report saying that we are the owner, we are entitled to get the
No,
copy.
the question of, no, I think Mr. Kormakar is not serious in this submission.
No,
With
so-
respect to ownership, then nobody gets compensation, only the administration gets compensation. Is he trying to say that?
Yes, I am not entitled.
Whether his status has been, discussed.
No, Lordship, grant. No, my lord, no. There is no.
Certainly not. Certainly not.
Lordship, grant. Because they file a civil suit for extension of grant period.
Extension of grant.
Grant period.
Means they are in position.
Yes.
I am not disputing that they are not in position, physical position.
Exactly. Kindly records that.
There should be some, because the position was given on certain condition on grant. I cannot deny it.
But either they can get level 4 or 1 crore, that is different.
That is different aspect. My specific defense is that not entitled.
Whether level
Not
4
entitled.
or 1 crore, that said by you in that case.
As far as scheme, they are not
That
entitled.
they need to assess. I bow down, my lord. First, my entitlement is there.
Or whatever it may, you have to pay.
Yes.
Exactly.
So you are saying that there is no order of paying.
Lordship, I already submitted, Lordship, wrong assessment,
Very rightly submitted.
entitlement,
You have very rightly submitted on that one.
assessment, entitlement.
You should appreciate Mr. Chairman.
My lord, absent. Bound.
If entitled, question of assessment.
According to the administration, government will pay compensation to itself.
Okay, thank you.
Lordship,
Get
yes.
you, my lord. Should be.
But I'm so grateful, my lord, for the discussion.
Are you going back today?
Yes, my lord, at 4 o'clock.
Sunrise pillar.
Ah.
Thank you.
Yes. During morning and evening, weather are pleasant here. But here completely
No, we are enjoying. We are enjoying.
grateful, sir.
Yes.
If you want to.
Now to the respondent, however,
What happened?
against acquittal, the prosecution has come before this honorable court. CRM number 1 is already disposed of by law.
Need a special leave.
Already
No,
granted
that has
section 5
been
allowed.
disposed of. Leave was granted, you have received the paper before.
So, acting is acquitted.
Yes,
Then why it has come on?
it is wrongly come in that way.
So which one the other side?
My
I
brother,
got this state, Lordship. I have filed the state appeal against Calcutta under POC Act, Lordship.
So, are you ready?
Lordship, just today morning I have received the paper.
unfortunate thing for me is my client is getting retired today without any benefit. This is the
Lordship,
last
today
day of-
morning I have received the paper.
Direct me tomorrow. Tomorrow.
I have no problem if you.
It's again
Lordship, today
acquittal, my
itself I have received.
This Mangar, please.
Today I have received.
They have filed the appeal. The complainant got hostile, other witnesses got hostile. There's nothing on that part.
Any day,
Yes.
Lordship, I will conclude
When
my
I
argument in this.
wrote a letter for financial benefits to me, they have come up with appeal after 1.5 months.
We are a council for this case, has sought for an accommodation. And yes, specifically. Okay, stop. Is the matter, of Christian. Of the all of
Well, I'm grateful.
Yeah, to get you. Yeah, you can have a problem.
58 of her.
No, it's not actually the power respondent. That is valid for the application as not for an application or you take its addition only respondents. This is where nothing. Hey, you know, you take this app, which you know, which that.
The Honorable Justice Kaushik Chandra has passed this order, so it has to be taken before. Madam.
Very order was passed by Honorable Justice. Office food. Then you get this before this watching.
Okay.
Carry on.
Civil case, you are a civil or not being filed.
I appeal lordship against Calcutta.
He's also a government servant. He's also against it.
When you
Under
are
POC.
when you are receiving.
No, it's long gone.
So you are ready. So we start.
Yes.
All of them. Another member that is for you. Maximum time. We have received special
Everything is ready for hearing.
Paper book already prepared also.
Transport report has. Ready. Okay, please start.
Lordship, right, please, Lordship. Lordship, the respondent accused was a revenue officer. Was a holding the post of whatever in the revenue department. The complainant filed one application for mutation of the ancestors' property.
Complaint.
Complaint with the complaint in the instant. On the basis of his complaint, they filed application. Or normal conjunction there. One
We find a application for
mutation of the landed property of his father amongst the legal aids. The being a revenue officer, Patwari concerned, demanded rupees 5,000. Then he reported the matter to the anti-corruption unit, police station, made a complaint, lordship.
corruption department.
Corruption, anti-corruption department, that is police station.
Which institution?
Anti-corruption unit.
Yes.
Thereafter, raiding trap team was constituted by the police station. Reached to the spot, taken respective position. Money was handed over between complainant and the TRO, that is trap laying officer.
All the rehearsals,
Everything taken place. Money, yes, money has been recovered from the position. Everything has been done. Everything has been done.
But that has been activity.
Activity.
Right?
Lordship, kindly come to the page number 1 by paper.
1.
Starting page. Number 1, that is charge. First page. First page.
Right.
Right.
Yes.
First. First page. Firstly, that you on 21 February 2006 have demanded illegal gratification of rupees 5,000 from Sri Ranjan Shikhar, such and such resident within the PS Ranga to start with tuition proceeding of the landed property recorded in the name of paternal grandmother of the complainant Ranjan Shikhar, and thereby you have committed offence punishment under section 7 of Prevention of Corruption Act and within the cognizance of this court. Second, that you on 9th March 2006, while you were present in the Tahsil office Rangar and you have accepted illegal gratification rupees 1,000 out of rupees 5,000 from Ranjan Sikhar for the purpose of nutrition proceeding, and the police of PS Rangar apprehended you by making a trap, and thereby you have committed a criminal misconduct in terms of provision 13 within bracket 1 within bracket T of Prevention of Corruption Act 1980, and thereby you have committed an offence under section 32 of Prevention of Corruption Act within the cognizance of this court. Under these two sections, charge was framed. Ranjan Shikhar, who is the complainant, was examined as PW1. Let's see page number 2 of the paper. The deposition of PW1. I am resident of Janakpur village, Rangas. We are 4 brothers, and namely Sudan, Manoj, myself, and Vishud. Yeah, paddy land of my maternal grandmother, and she wished to transfer the said property in the name of we 4 brothers. And same was accordingly a deed was registered in our name in the year 2004 to AC office Mayamanda. Thereafter, we applied for joint mutation of the same at the Tahsil office Rangar, as there was a tsunami in the year 2004, and due to same the mutation was not done. In the year 2005, I again proceeded to the Tahsildar officer for same, but that was not done. Thereafter, in the year 2006, I again went to the Tahsildar officer and found one new Patwari, namely Hari Krishna, was posted there. Accordingly, I meet with him. He is the respondent here. Thereafter, we again applied for joint petition before the Patwari. As my work was pending 6 long, I again met the Patwari, and Patwari stated to me that as it is long pending dispute and some cost is required for correction of record of right and for preparation of the map, he demanded rupees 5,000 from me for such work. I then told him that I will consult with my brothers and thereafter will come. My brothers were not wanted to pay any price, so I informed the matter to PS Anti-Corruption Port Blair. The officers of anti-corruption told me not to give any price and requested me to delay the matter on the ground that the money was not arranged, and also instructed me to pay and drive on the instruction only. Next page. Thereafter, I again met with Patwari on 21 February 2006 and prayed for some time to arrange the money. Thereafter, 9th March 2006, the officer of anti-corruption called me over telephone and told me that they are coming at Rangar and instructed me to meet them at Rangar. Accordingly, I met with them at Rangar at one RT Lodge. Some documents were made at that place. I also put my signature on this document as per the instruction. Letter of complaint is shown to the witness on the. This is a complaint letter written and signed. The complaint letter is marked as Exhibit 1. That is first complaint. With objection and signature is marked Exhibit 1 by 1 with objection. Thereafter, some chemical was shown to be including some powder and liquid. When the powder was put into liquid, the liquid changed its color into pink. I handed over rupees 1,000 denomination of 1 GC notes of rupees 500 and 5 GC notes of rupees 100 each. They also treated the money with the powder. Thereafter, they handed over the said money to me and instructed me to hand over the same to Patwari. At that time, 4 police personnel, 2 government clerks, namely Bhaskar Rao and 1 Ali, were present there. So, pre-term proceeding regarding exchanging of money, powder, etc. This is my signature on the document. Witness identified his signature on the pre-term memorandum containing 3 pages, and the signature are marked Exhibit 2 by 1 series. I then proceeded towards residence from office of the Patwari at Nimbutala along with the police person and those 2 clerks. When we are on the way, I saw the said Patwari crossing us by a bike. When we then also turned the vehicle and followed the Patwari, we reached the office at Rangar. Then the police person instructed me to go to the office of Patwari along with 2 government clerks. The police personnel stayed nearby outside. Thereafter, I entered into the office room at Patwari, handed over the money and stated that the rest amount of money would be given later. He then asked when the rest money would be paid. I then assured him that the rest money would be paid within 2 to 3 days and requested him to start the work. The Patwari took the money and kept the same money in the pocket of his shirt. Thereafter, the police rushed into the office room and hold the Patwari, and thereafter the hand of Patabody was in a liquid and the liquid changed its color into a pink and thereafter the pink color liquid was kept in a bottle. The pocket of the shirt of the Patabody was also washed in some liquid and the same was also changed its color into pink. The pink color liquid was also kept in a bottle. Therefore, the money was seized by the police. Witness identified his signature over the recovery memo containing 3 pages. Signature is marked as Exhibit 3/1 series. Then cross-examination. Lordship, here kindly see the evidence of the de facto covenant. Specifically stated how it, because this complainant was uneducated farmer by profession, so was ancestors' property. Technical regarding some contradiction has came in the cross-examination. So for minor contradiction, the entire version of the PW1 cannot be thrown away. If there is some corroborative evidence in respect of shadow witnesses, how the shadow witnesses has corroborated the evidence, the reposition of PW1, that has to be seen by this honorable court. Then PW2 is a B. Bhaskara. He was working as the electricity department, that is page number 7. Page number 7 of the paper. May I read first? I am now posted as head clerk in the office of executive engineer, electricity department, Port Blair. On 9 March 2006, I was posted at CD APW Rangoon as a higher grade clerk. I used to decide the government quarter. I know Rahul Ali, who was the working in the office as high grade clerk. On that day, as per direction of executive engineer CD Rangoon, I along with Rahat Ali accompanied one of the staff of anti-corruption to a lodge at Rangoon at about 1:30 to 2 p.m. After reaching at lodge, we found 3 to 4 persons. So it is shadow witnesses arranged by the police station because it is procedure to see the shadow witnesses. Lordship. At the lodge, we were informed that there was a complaint by one Ranjan Shikhar and Hari Krishna. We came to know that the Sri Hari Krishna was a part of it. Rupees 1,000 out of which one was rupees 500 and rest were 100. Denomination was produced by Ranjan or by somebody else. Powder was smeared on the DC notes. After smearing the powder, the DC notes were handed over to Ranjan to give the same to Patwari on demand. Thereafter, we all proceeded to the Tahsil office Rangoon by effect. There were 3 rooms. Ranjan went inside the room of Hari Krishna. I went into another room. When I came out of the room, I heard that Hari Krishna was arrested. Hearing this, I went inside the room of Hari Krishna. One of the staff of anti-corruption brought out DC notes from the pocket of Hari Krishna. The DC notes were put in the solution and shirt of the Hari Krishna was also washed in the solution. Thereafter, the solution was kept in a bottle.
DC notes also in liquid.
Shirt also.
DC notes are put in the solid.
DC notes were put in the solution and the shirt, yes, it is deposition of the deposition. Yes, it is a deposition. What happened, Lordship? It is record, I cannot go beyond this. In the meantime, public also gathered there. Thereafter, I came to PS and signed on the some document, and that is Peter recovery. I will not take much time this part, Lordship. That some documents have been prepared. Then Rahat Ali, PW3, page number 11. He also shadowed me.
Yes, also supported prosecution.
Prosecution. He also supported.
No. My brother is misguiding this honorable counsel.
No. Even if try to, if anybody tries to misguide, both is not
By this, my humble.
What is in the record of it?
No, he must.
But with the shadow of this, maybe some contradictory statement. Maybe some contradictory. I cannot misguide. Maybe some contradictory statement. And PW4 is the page number 40, from whom that brass steel was seized. Because after some procedure, brass steel was used by the police personnel for seizing and packing. So brass steel. Then PW5 is the Chitti Babu. He also brass steel was witness, page number 16 or so. And PWC with the police personnel, he was also member of the rating team. What is Lordship? PW6, page number 8. Yelangoban,
Yes.
you also was with the reading team, Lordship. I will not read out the entire things, Lordship. This all witness, Lordship, has corroborated the deposition evidence of PW1 and PW18.
FSL report.
All are positive. All things have been found. Everything has been found. So that is a matter of record. I will not go through and read out the entire documents.
Why the judgment is wrong? Why the judgment is wrong?
Not sure, I am coming to that. Just because, Lordship, I also found some minor contradiction between the statement of all the prosecution witnesses. The trial court,
But they are not fact. So we
according to me, because, Lordship, is under prevention of corruption. Shadow witness, true witness corroborated the evidence of the PW. In somewhere, cross-examination, Lordship, independent. Why, Lordship? Shadow witnesses always used to take by permission through a secretariat staff, administration staff. Because the complaint received secret information, chief secretary is the chairperson of the vigilance. So, two shadow witnesses was taken from the secretary administration. That was it to the here, Lordship, only on the ground of benefit of doubt. Doubt was created before the trial court.
that is the only
Ground for a good. That is not only, Lordship.
that is the duty of the
Of course, Lordship. Of course, Lordship.
If
If even a 50-50 doubts created before the mind of the trial judge, even that option, I cannot say that benefit also have to be give to the favor of the accused, even a 50-50. But here, Lordship, I did not find I did not find any that which point has created to the mind of the trial court judge that the accused should be acquitted from the instant case. Because the complainant stated that the accused demanded money, specifically stated in under 7 and 13(1)(d), demand and acceptance has to be proved by the prosecution. Here, demand have been proved, acceptance because all recovery seizure have been made from the pocket of the accused. There may be some contradictory statements.
nutrition fee at that time?
Lordship,
Very right. What was the nutrition? 200.
no, very minimal.
Prosecution during the entire investigation, my lord, they could not produce that document. Whether they pay any nutrition.
Nutrition certificate.
Yes.
Lordship,
And my lord, I'm sorry, I'm better than my elder brother.
That's what you meant.
Lordship,
Before lodging of the FIR, the nutrition was record is there executed.
but Lordship, I argued this point with the trial court. Lordship, being a villager, uneducated person, going to the Tahsil office since last 5 to 6 years, some Patawari saying work is not completed.
No, if we first, we have 10,000. If the nutrition fee is say 500 at that point of time, why 1,000 rupees are given? Certainly, something in favor of prosecution.
Lordship, nutrition fees at that relevant, I think 15 rupees or 10 rupees.
Is not on record.
That is not on record. But
I am asking.
But the defense case is mutation was done before making an complaint. Lordship, I already stated that being a uneducated person, he is going to the office every day because he wanted a result that what happened our mutation case, Patawari changing, transferring, that this Hare Krishna came there. Mutation done or not, that was not known to the applicants. Defect of Lordship. Then why he did make a complaint? Any enmity, falsification, no evidence at all from the side of you. Of course, it is a
And
duty.
recovery of alternate form is okay, very background. If that is also proved, then he has to.
Lordship, that was what points of that benefit reason that created.
It may be show that I have already done your mutation, now give me.
Lordship, that argument I made, Lordship, regarding Lordship, overall Lordship, mutation done, not done, then why the complainant made a complaint that my mutation was done? Because he was unaware whether my mutation was done or not amongst the ancestor property, amongst the legals or not, or that is then he made a complaint. So it is proved demand, acceptance, recovery of money from the pocket by way of shadow test PW2 and PW3. That some onus, of course, lies upon the accused person. It is of course the duty of the prosecution to prove the case beyond all reasonable doubt.
So you have said that the mutation has already been done.
I never said, I said only, record saying, Lordship, on the basis of the statement of the de facto complainant, mutation was not done. Mutation was not done.
So he has submitted the mutation fees that receipt has been.
Receipt not, some application, all are within the record. Mutation application,
Money receipt is not.
notice of mutation.
From official document, anything has.
Yes, exhibited, Lordship. Exhibited. Mutation notice. Exhibited. Page number.
Yes. Okay. Everything is there, but you do not understand why language judge has acquitted.
Lordship, page number 91, notice to mutation to interested person. Page number 91. Page number 92, the signature appearing among the legal heirs. Sujoy Sikdar, Mona Sikdar, Ranjan Sikdar, Vishnu. Ranjan is the complainant. So proceeding started, the defense cannot deny that no mutation, no work was pending or something like that. The mutation started, but question by learned friend defense raising that mutation was done. If mutation was done, why the patwari did not inform the person? Why the complainant daily going to the Tahsil office after taking the notice also for mutation? So my respectful humble submission, I did not find any major contradiction between the prosecution witnesses wherein the trial court has taken that part that the benefit of doubt. So I pray, Lordship, the appeal is liable to be allowed and it is liable to be convicted.
How much punishment you want?
My lord, kindly come to PW1.
So it will take some time.
15 minutes, 15, 20 minutes.
Now, first up, you can come back tomorrow.
Tomorrow, my lord. At the top 100 party. I'm grateful, sir.
I write it. I tell here because this is my. I have to dispose of.
My lord. It's a ready matter, my lord. I just satisfy my lord to the score what my brother is asking.
Very good. Right, sir. आगे क्या हो गया है? Planning council for the state as possible solution of the planning council for the responding against committee. Really is argument. It's the matter of thought.
I'm grateful now.
Within 5 minutes. And he will take 15 minutes. Huh? Definitely.
I'm grateful, man.
I'm so good. I'm going to give you. I'm going to give you.
Oblige, Lordship.
नहीं एक्सपोज होती है बड़ा सा तो देखता नहीं ऑफिस को ना ऑफिस में देखता नहीं है बस